Hello everyone, and thank you for joining today's seminar covering the East of England and the implications of the White Paper. My name is Welwyn Bolton, for those who don't know me. I'm a Senior Director at DLP in charge of the SPU unit, and I'll be today's chair. I'm delighted to welcome you to another DLP webinar covering a range of practical planning themes. And DLP, as you know, operates out of a number of office locations, including Bedford, Milton Keynes, London, Nottingham, Rugby, Sheffield and Bristol. And we're aiming today to complete the seminar in about 40 minutes with presentations, leaving some time for questions. We are happy to welcome today Victoria Hutton of 39 Essex Chambers, who's joining us, Catherine Barnes of also 39 Essex, who's joining us, our very own Andy Parry from our Bedford office, and myself. And if we can go to the next slide, just to give you an idea of today's webinar. Firstly, Andy Parry is going to take us through the experience of plan making in the East of England. I'm then going to look at the implications for plan making in terms of the White Paper and the new standard method and the implications that might have for the East of England. Victoria then is going to pick up the experience of new settlements, if you like, in the development plan system and how the White Paper might affect the promotion of those. And we're going to end with the Building Beautiful, the design codes and extension of PD rights, which are also being proposed in the White Paper. During today's presentation, if you feel free to ask questions, we have a Q&A box which is running, so please use that, or indeed use the email and email us questions. We'll try and pick those up as we go through, and definitely at the end. If anyone's connection drops out, please just rejoin using the same link as before. And at the end of the session, we will circulate the slides as well as, if you like, some key takeaway points that are being raised in the session. So without any more ado, I will pass you over to Andrew Parry, who will take us through recent plan making in the East of England. Andy.
Thanks, Roland. Good afternoon, everybody. Hopefully you can see the slides. I'd just like to kick off with a quick introduction to the Bedford office. In normal times, we're based in our headquarters on the edge of Bedford. We also have a satellite office in Rugby, which serves the West Midlands region. We're currently acting remotely, as most people are, with a team of about 12 qualified planners. It's the home of our MD, Simon James, and Neil Osborne, who I'm sure many of you are familiar with. I'm also based there, as is our other director, Amanda Bolson. We're doing lots of work, as that map shows, across the East of England region, particularly in Bedfordshire, Buckinghamshire, Hertfordshire, Northampton, Cambridgeshire, but we're also doing a lot of work now in Norfolk, Suffolk and Essex and Lincolnshire, and we're also stretching down into Oxfordshire as well with some projects in that part of the world. So the focus of today's webinar is obviously the White Paper, and I thought it would just be useful to do a sort of bit of local context and background to the White Paper and to the presentations that are about to follow. A key thrust of the White Paper is clearly the need to speed up the plan making process. So I thought it'd be useful to highlight the famous five, as I've called them here, to set a context, and these are 5 plans that DLP as a company have been actively working on over a number of years, and I think it's useful to show a sort of lessons learned before we then go on to talk about the new system. So the aim here is really to sort of set out what the government should be grappling with in the White Paper. I'm afraid it's a little bit of a whistle-stop tour because of the time constraints, but I'm sure many of you will be familiar with the issues that are raised anyway, and some of the plans that we're going to talk about. So to kick off then, in leafy South Bucks and Chiltern in Buckinghamshire, This was a joint plan that covered both local authority areas and was submitted to the government in September 2019. Initial hearing sessions took place as written statements, primarily due to COVID-19 and the lockdown. So it was quite an unusual situation where the examination started remotely through written statements. It's fair to say in South Bucks and Chiltern there have been a series of ongoing issues in terms of constructive dialogue with their neighbours, particularly in this case Slough, and deciding on where Slough's unmet needs should go, particularly because Slough is a Labour-controlled authority with a very tightly drawn boundary. Chiltern South Bucks is a Conservative authority which is heavily constrained by Greenbelt and AONB. Whilst I think in this case there was definitely discussions that took place between the authorities, these were not, well, the inspector's view in this case was they weren't sufficiently constructive, active and ongoing to pass the duty to cooperate test. So he wrote, or he and she, I should say, wrote to the council on that basis. Now that was initially resisted quite strongly in public by the council. However, summer months have gone by, and the council took the decision this week, actually this last week gone by, to withdraw the plan and focus their resources on the Buckinghamshire wide plan. Interestingly, the Vale of Aylesbury plan, as far as we're aware, is still ongoing, and that's also been in examination for a long time. It remains to be seen whether the issues of Slough's unmet need will go away. I mean, I suspect they won't, but there's a question mark here arising as to if the duty to cooperate is scrapped under the government's proposals, which we'll come on to. Does this problem go away for Buckinghamshire, if not for Slough themselves? So there's an interesting question mark to go forward on that one. Moving on then to central beds, which is one we're acutely familiar with, being in our local patch. This is a second attempt for central beds to get a plan through the process following their failure of their development strategy back in 2015-16. That was found unsound on the duty to cooperate issue as well. The council is still operating under a fractured development plan system, with the former mid beds and south beds legacy so still around in terms of planning policies. So there's clearly a need for a consolidated local plan. That plan was submitted, the new plan was submitted back in spring 18, so that's 30 months ago now. I think it's fair to say it was one of those plans that was rushed through the process in order to get in under the old 2012 MPPF transition. So the deadline for which was January 19, and that's, I mean, it's justified, I think, in Central Beds' case by the fact that there was a significant uplift in housing requirements if they were to be assessed against the standard method, somewhere in the region of 700 houses a year increase. So you can sort of understand the rationale from their point of view. The hearings on that plan started in summer last year. The duty to cooperate wasn't so much of a stumbling block this time, as there was broad agreement in terms of Luton's unmet needs, because the Luton plan has since been through the process. But it's fair to say the inspectors had some significant reservations about the sustainability appraisal process and the process of selecting sites, particularly the larger strategic sites. Inspectors wrote to the council inviting them to withdraw the plan, but this sort of led to quite a public spat between the inspector and the council, which I'm sure many people have been listening in on. However, ultimately the inspectors seem to have caved in now, and what's happened is there's a process of Central Beds sort of redoing their evidence base, commissioning a completely new sustainability appraisal to retrofit the process. There was consultation on those that evidence base over the summer, and at the moment hearings are set to reconvene in December. On to neighbouring North Herts. This is one of the longest running plans that we're involved with, which was submitted back in June 2017. Again, this is one where a substantial amount of evidence has been produced or republished during the examination process and the reconsultation on those. The inspectors raised concerns about the overall level of objective assessed need and the approach taken to Greenbelt sites. Also to throw in the mix in North Herts is there's a change of political control at the council. So after the May elections last year, there was a switch from a Conservative-led authority to a no overall control, after which there was a Labour-Liberal coalition that took power. And that ultimately has led to a change in direction. And actually, the hearings were meant to reopen this September, just gone, but the council took the decision to seek to alter the housing number based on the government's proposed new standard method, which Roland will come to talk about shortly. So that's led to a further postponement of the hearing sessions, and I think serves to highlight the impact of politics on the local plan making process, and how delaying a plan process can lead to further delays because context change, government policy changes. So that's clearly something that's come out of North Herts. Then to St Albans, again another one who are attempting to have a second bite at the cherry, as it were, after failing the duty to cooperate the first time around with their strategic local plan back in 2016. I think this time St Albans have tried to grapple with housing needs better than they did the first time around, but the approach this time has been to allocate a new garden village of 2,000 houses over at Radlett, which actually is on a site that's already got planning permission for a strategic rail freight interchange that was granted by Hertfordshire County Council. So clearly there was issues there in terms of that site. The inspector, I think, has concluded now that there was a failure to cooperate with Hertfordshire County Council in particular on that issue, and engage constructively on an issue that was of strategic importance to the region. And there were no other sites put forward for that freight interchange. So it also raises question marks about the deliverability of the garden village. St Albans now actually have reluctantly agreed to remove that site, but what that means is they have to find alternative sites, and that requires some greenbelt assessment and also further sustainability appraisal. So there's almost restarting the site allocation process again. And the latest update is actually that the council have reports being taken to the Planning Policy Committee on the 3rd of November, recommending that plan is actually withdrawn again. And last but not least is Welwyn Hatfield, one that we're heavily involved with as a company. It's got the prize here for the longest running examination, which has been ongoing for 41 months and counting. It's again another authority arguing for a lower housing target under the 2012 framework arrangements. The inspector here again has raised question marks over this approach, but also the evidence underpinning some of the allocations, particularly the larger greenbelt ones. The inspector there asked the council to go out and do a further call for sites during the examination process, which has led to more consultation, more delay. And again, it's another context, an example of changing context where an inspector's asked the council to reassess their OAN in light of changing household projections that were released last year, the 2018 based projections. We understand that more hearings are due to take place in February next year, so that's another 6 months away, which adds to the length of time it's taken to examine that plan. So just to pull out a few key themes then from our lessons of these examinations that we've been involved with. Clearly, I think the government's extended 2019 transition deadline for submission of plans hasn't been helpful, because it's allowed local authorities to, I think, hastily put plans together and submit in order to avoid a standard method figure, which in this part of the world is often quite a bit higher, certainly in the east of England. And then what that means is then councils are having to retrospectively produce evidence in order to justify the strategy that's going forwards. Inspectors seem increasingly reluctant also to throw plans out. The aim very much seems to be to get plans in place, even if that means rewriting the plan and the evidence that underpins it. One exception to that, which is worth mentioning, I think, is Bedford Borough, where in that case, rightly or wrongly, the inspector took a pragmatic view and got the plan through the process relatively quickly with very few changes. However, he did commit the council to an immediate review, starting within a year of adoption, and submission of a plan within 3 years. Interestingly, however, Bedford Borough is an authority with no greenbelt or AONB, so arguably less controversial plan in many respects. As I've said before, delays or a drawn-out examination process is often self-perpetuating, because that allows for changing context, changing politics, changing government policy, which leads to further consultation and delay. And we've seen that already in North Herts in terms of the white paper, where the changes to the planning system, where a proposed change in the standard method is being used to delay the plan and rewrite key parts of it, including the housing target. Remains to be seen whether the inspector will accept that. Duty to cooperate is obviously a clear stumbling block for many plans, particularly those in heavily constrained areas with greenbelt, etc. I'm sure we'll talk about this later, but the white paper proposes to scrap the duty to cooperate altogether, but it's not clear at this stage if or how it will be replaced by something else on a strategic level. And clearly, finally, that COVID-19 has obviously delayed things, but to be fair to PINS, I think EIPs are now up and running as virtual hearings, so things are starting to get going again in that regard. And just finally then, to conclude, and I think this will lead on to the presentation Roland and others are giving, the white paper response to these issues, I think, has been to target a more streamlined and engaging plan making process, which includes a statutory timetable for local plan preparation. And I think you can see there on that slide from the stages that the government have set out, they're looking at a 30-month process, and that's from start to finish. So plan preparation and examination. Now, clearly that's going to be a challenge, and given that authorities have taken more than 30 months just at examination stage, in terms of the examples that I've given, it remains to be seen whether that is achievable and at what cost. Thank you.
Thank you very much, Andy. Yes, some of those plans started when I felt like a young man. Seems to be a long time ago with some of them. We're certainly going to have some plans, I think, which are going to take us at least to 2025, but actually be based on the 2012 guidance. Whether they become zombie plans, which I think one member of the bar has described previous plans as, remains to be seen. So thank you, Andy. Has anyone on the panel got questions for Andy?
Andy, I've got a question. Is setting statutory plan making targets a good idea, do you think, or do you think that what's going to be compromised in terms of speed is going to be the quality of the plans produced? Do you have any comment on that?
Yeah, thanks. Clearly, I mean, I would hope that the message from my presentation is that something has to be done, because we can't keep on like this, where things are taking 2, 3, 4 years to get through the process. I think simplifying the local plan process, as I think Roland will be setting out in his presentation and others, will hopefully make the process quicker, particularly if housing targets become standardised and development and control policies are stripped out and done at a national level. But I still think, to establish growth, renewal and protection areas, there's going to have to be a lot of thought and a lot of consultation with local people, because they're important. And I do worry if the process is rushed that there'll be an impact on the quality and the evidence base underpinning those sort of key decisions. I think it also jars a little bit with the government policy to get more people engaged in plan making. I think if you're going to do that properly, that takes time, and adhering to sort of arbitrary statutory deadlines could jeopardise that the quality of that consultation. And I think it should be about making good plans and not just rushing something through. So, and that's what we saw when the NPPF 2012 deadline was enforced. Plans were just rush through the process in order to get something in, and then retrospectively unpicked. Excuse me, I do think there may be a case for statutory, in my view, the statutory timescales for the examination process itself, putting the plan making side of it to one side, and arguably you could have some statutory tests to say that, you know, if the plan doesn't get through the process in a certain time scale, inspectors are obliged to throw the plan out and go back to square one, rather than this process we have at the moment of just sort of continual reconsultation, new evidence. I think there has to be you know, that process has to be shortened somehow. In terms of sanctions that the government have talked about, there's very little in the white paper. I think all they've said is, you know, there will be some sanctions thought about. So who knows what that will be? But one option, I suppose, is that the Secretary of State could intervene if a council or an inspector doesn't get to a decision quickly. But I'm not sure whether MHCLG have got the resources to be doing that up and down the country. So I guess we'll wait with bated breath to see what those sanctions might be.
Thank you, Andy. If we move on now to, I'll quickly review what's coming up in the what's in the white paper. The white paper is, the consultation on the white paper finishes in 3 days. So if you have views, certainly make them known to the ministry. As Andy says, 5 stages to the new local plan process. The important thing here is stage 3, the consultation period, which is only due to take 6 weeks. It's meant to, if you like, be cutting edge consultation. So people using webinars, etc., is going to be a way forward to reach more people. Interesting things that the white paper says about 30-month timescale. It says that engagement in plan making will stop objections at the application stage, because everyone will be consulted and agreed at that stage, which is an interesting and optimistic view, I think, of plan making. There is going to be no test of soundness. It's going to be a single test of sustainable development. There'll be no duty to cooperate, to answer Andy's point. So all these issues which Albans and others are having basically disappear. There will be no 5-year land supply test. So plans will simply, if you like, become out of date, or the trigger of the presumption will be dealt with in what's been built in the past against, if you like, either the standard method or indeed the plan requirement under the housing delivery test. So quite a big change. The other big change, obviously, is the 3 growth zones, which everyone's heard about. What's interesting is we've got no idea what size these might be, or actually what each growth zone might allow in each area in terms of renewal, what will be allowed in terms of infill. Both growth zones and renewal will have a presumption in favour of development, where the protection zone won't. But the protection zone, as when it first came out, could be applied to most of an area and would include not only the green belt, the OAMB, but also things like the countryside. So quite a big change there, and potentially a higher level of protection rather than a lower level of protection that everyone was talking about. Some of the alternatives that have been floated, quite interesting ones. LPAs should be allowed to self-assess their plans against a set of criteria and guidance. So there's no examination at all, because they will actually be allocating enough land for housing, so there won't be a need to examine them in any way, shape or form. And there will be no automatic right for objectors to a plan to be heard. Again, quite a significant change. In terms of SIL, again, a potential significant change, doing away with SIL, getting it down to a single infrastructure levy. That will either be a flat rate across the country or a varied rate. The idea is that it will capture a greater uplift in land values, or capture more of the uplift in land values, so deliver more infrastructure and more affordable housing. Now that only comes from one point, really. That comes from the uplift in land values. So it's effectively a further tax or a standard tax on land values. It might be better in that it's clearer, but one will have to wait and see what the responses are. Turning to the standard method, this has been trailed quite a lot. 3 steps. So for me, it's 3 steps. Firstly, starting off with most recent household projections, but they only look at migration over 2 years. And you take either those or a 5% increase in stock, whichever is higher. You apply 2 types of affordability and ratios to them. One is the existing one and one is a change over time, which again seems to make quite a lot of sense in that you measure people not only where they are now, but how they've managed change. The most important thing, and probably the one that's going to be of most interest in how it works, is once you've got to your figure in step 2, that will then be moderated to reflect the constraints within the district. Now, that moderation is going to be done by central government. How it's done, how open it is basically left in the ether at the moment. So, very interesting point. What it means for the east of England, go to the next map. The areas in dark red are areas with over 1,000 dwellings per annum required, such as Southend-on-Sea, Uttlesford, South Norfolk, East Suffolk, Hunts, Bedford and Central Bed. So a fair number of districts looking at a fairly substantial uplift. And that compares to what was proposed under the old standard method. And you've got the comparison here, if you like, side by side of old standard method to new standard method or proposed standard method. And what you see is overall there's only a 12% change, but there are some districts that have to provide 50% less, but there are also some districts such as Malden and Norfolk and Baber who are 90 to 100 have to provide 100% more. That's not really the issue. The real issue is where does the new standard method take us against existing local plans? And here, the uplift is much more. It's at 43% overall for the whole of East of England. And there's some very big levels of uplift that come out of the calculation. But of course, this isn't the final figure. The final figure will be determined by central government by reference to Greenbelt on the left, which bizarrely in this slide is orange, but that is the Greenbelt surrounding London and Cambridge. And also in this area, the other big constraint will be flood risk. So the numbers you saw on the last page will be amended, if you like, in order to reduce, and that they're only going one way, they're only being reduced. So that leaves us, if you like, with the comparison of the local plan and the 2014 and the 2020 revised method. I've just picked out a few here that we're involved in terms of Bedford, a marginal uplift by about 20% if they were from the current local plan as adopted. In terms of central Bedfordshire, it's an uplift of 40% in the most recent method, 26% on the current method, because obviously central Bedford was deposited under 2012. Epping Forest, out of all the ones we're involved in, that would have the biggest uplift under the new method. North Hertfordshire, as we've seen, would go down under the new method, and politicians have already taken a report to North Hertfordshire to try and reduce the number in the current plan. That didn't get passed. And Welwyn and Hatfield again would be an uplift on what they're currently planning. But the point, I think, on all these is what you see, the politics of it is when something comes through and there's an uplift, that always gets taken through the planning system and the development plan system, and that takes longer. If any of these, if the new standard method requires a reduction, that tends to get factored into wherever the plan is at the moment. So what you have is the reductions are always factored in quickly, the uplifts always are taken longer and longer through the process. So just on finishing that, one of the ways of tackling the higher rates required to meet 300,000 dwellings that the government's advice is to look at new towns, and the East of England has experience, and Victoria indeed has experience in looking at new towns in the East of England. So I'll pass on to her to run us quickly through, if you like, her experience in new towns, the white paper in the East of England. Thank you, Victoria.
Roland, thank you very much for that. That was a whistle-stop tour of a couple of the consultations that are going on. And I think what that highlights, given the amount of content that you had to summarize in such a short time, is just how much is up in the air at the moment, and what a difficult time particularly local authorities are having at the moment, working out, you know, especially those ones that have got plans going through the system. So that was perfect. So new towns. Well, on the slide before this, I had Poundbury pictured, which possibly many of you will recognise as a good example, I thought. Nansledden, the other Duchy of Cornwall, made it into the white paper with a number of pictures of it. But that's not necessarily the case for all new towns. They're not necessarily as beautiful or as celebrated as those two. So I wanted to look at what the white paper means for new towns. Well, and the headline point is it's pretty difficult to say at the moment. So the white paper envisages them being part of growth areas. And we know that Roland's taken us through the traffic light system of growth, of the red, amber, green system, green being growth. But it also says that for exceptionally large sites such as a new town, where there are often land assembly and planning challenges, we also want to explore whether a development consent order under the NSIP regime could be an appropriate route for consents. And that's particularly interesting in my view, because of course the DCO process at the moment takes place outside of the local plan system. So at the moment, if you propose a DCO, you don't have to meet your section 38.6 test. You meet the test under the Planning Act. And broadly, if there's a national policy statement covering your development, then if you comply with it, generally you'll meet the test. There's some exceptions. And if there isn't one, then it's a much more broad brush approach that the Secretary of State is able to take. So what this leaves up in the air is, well, is there a proposal to take new settlements simply out of the local plan regime and wholly into DCO and have a national policy statement which would cover them? Or is there to be some sort of hybrid process where one could have a local plan allocating a growth area for a new settlement, but then one uses the DCO process where the decision maker has regard to the local plan? The devil will be in the detail, and although we've got a huge amount to discuss, the truth is there's a huge amount of detail missing from all of these proposals. So I think, so if we just go, yeah, perfect. The white paper includes new settlements, but it certainly, I think we can say it doesn't champion them. And so therefore, given there isn't a separate section on new settlements, what it is useful to consider is if the proposals are brought in, and we have the 3 areas, and we have 30 months for plans, etc., what will that practically mean for someone who wants to promote a new settlement, or indeed a local authority who wants to allocate a new settlement? So in order to do that, I thought it would be useful to address what's happened with regards to some settlements in the East of England. And this is the next slide, please. And the ones I've picked out, which are probably the obvious ones, which have run aground, are the North Essex authorities and Uttlesford. And actually, in view of time, I'm going to focus only on Uttlesford. It's the most recent one. It's also one I was heavily involved in. For those of you who are not familiar with that plan, the plan proposed 3 new settlements, one at North Uttlesford, one at Easton Park, and one west of Braintree. and together they were proposed to deliver 18,500 houses. Now, the housing requirement for the local plan was 14,000 houses, apologies. But of those, only around 4,000 were going to be delivered by the new settlements. So the vast majority of the new settlement development was going to come forward beyond the plan period. Now, the inspector, Uttlesford had a whole host of issues with their local plan, but with regards to the new settlements, the inspectors were concerned when they wrote their letter following the examinations. They were concerned by the lack of evidence justifying the proposals. And they emphasised that given these proposals are setting down development for the next 30 to 40 years, they need to be properly evidenced and justified. They were concerned that boundaries weren't defined. So on the local plan proposals map, the new settlements were set out as just lozenges of appropriate for development. And that's interesting if we think of what growth areas might mean. I'll come back to that in a minute. There was a concern that there was a lack of recognition on the council's part as to how complex and challenging it is to deliver 3 new garden communities, and a lack of appreciation of potential delays. There was also a concern about this fact that 1,400 of the homes being proposed in these new settlements would actually come forward beyond the plan period. And the inspector said, well, look, we don't know what the need is beyond the plan period, and therefore, you're setting down all of this development. The effect may be to stifle other sites coming forward and to inhibit the sustainability of other areas. And then there were viability issues concerning particularly interest from borrowing and peak debt, which is clearly extremely important to consider where you've got a new site, a new town, which will have significant infrastructure costs up front. And then there were other issues with the individual settlements. So taking those issues, and again, many of those issues were found to be the case at North Essex when they were first looked at by the inspectors. But taking those issues and then looking at what the white paper proposes, I think we can make some comment as to what the impacts are going to be. If I could have the next slide, please. So the first point is that the white paper envisages a minimum plan period of 10 years. Now that is extremely short in the context of new settlements, because as we know, even if you've got an allocation, there are likely to be a huge amount of preliminary works necessary to get the sites ready to be developed. So it's unlikely that you're going to have material delivery of housing until the second half of the plan period. And that's even with a fair wind, I think it has to be said, and on the simpler sites. So if you've got a settlement of, say, 2,000 houses or more, a significant amount of that development is going to come forward beyond the plan period. Now, that may be less attractive to local authorities who are concerned to ensure that the housing they plan will be delivered soon. Also, I think it's going to emphasise that problem of a mismatch between the assessment of environmental impacts, which often take place only for the plan period, and the reality that much of the development will come forward after that time. There's also the 30-month time period to get plans in place. Query whether that's too short for new plan proposals. We know there's a huge amount of work that needs to be taken to justify new settlements, and that, whatever process is used, at the end of the day, whether it's local plan or DCO, they're going to have to be justified, and the evidence has to be there, and that will involve a significant amount of upfront work. And so it may be that the 13 months is just too short, and effectively one will end up doing half the work and then have to wait for the next local plan review to try and get the site allocated. And then finally, not on the slide, but is the issue of growth areas. We don't have the detail as to what those will practically look like. But remember, at Uttlesford, the inspectors said, well, you can't just simply have a growth, what was effectively a growth area. You need, because these are so integral to your plan, you need to have set down the boundaries in order to have properly assessed them. So there may be some difficulty there. So I think probably on balance that there's a question whether the white paper really supports or hinders. I think probably hinders, but at the end of the day, these may all be taken out and put through the DCO process. But as I say, the devil will certainly be in the detail. Thank you, Roland.
Thank you, Victoria. Yes, certainly a minimum 10-year plan period does tend to suggest short-term thinking and encourage short-term thinking. So it doesn't encourage councils to make difficult long-term decisions. And I think the point you raised about growth areas and the evidence one might need to allocate them or new settlements as growth areas in the future under a different regime is an interesting one. Has Pam got any questions for Victoria?
Yes, I've got a question. I was wondering if you could comment in a little bit more detail on how, if one was promoting a new town, that could be done under the White Paper's new regime and this new growth area mechanism. How in practice do you see that working?
Yeah, thanks, Catherine. I mean, I think, again, obviously a lot's up in the air about whether these come through local plans or DCOs. But I think either way, the answer is going to be a significant amount of work being done up front. The proposal is going to have to be justified evidentially. Also, many stakeholders are going to need to be brought on board. You know, the reality is getting an allocation if you've got an objection from the Highways Authority, or even actually North Uttlesford, there's an objection from Historic England. So all of those consultees will need to be worked on. I mean, there's no one-size-fits-all approach because every site is different. And actually that may be a lot of what's the problem with the white paper, but perhaps we'll come on to that. But yes, I think it really is actually just as it is at the moment. It's really getting all of the evidence in place, justifying it, anticipating the problems and dealing with them. In order, you know, you're going to, with any new settlements, you're going to have a battle, you're going to have a significant opposition, not only from the local or potentially from local people, but also from sites who haven't been allocated. So tool up and make sure that everything's in place and pucker.
Okay, thank you, Victoria. And from the potential mess of what might occur with the emerging local plan system, Catherine, can you take us through something much more positive, which is building beautiful?
Yes, well, I hope it's positive. It may, I think probably the theme of my presentation is uncertainty, so positive yet uncertain. I thought it was important to say a few words about this aspect of the white paper because if I can have the next slide, please, thank you. There are 3 pillars that form the white paper, and the second is entitled Planning for Beautiful and Sustainable Places. And understandably, a lot of the focus has been on pillar 1, just because it does seem very radical. But clearly this is a key part of the white paper and so deserves attention too. And then the aim that the government set out is as follows, and I don't think anybody could quibble with the aims, well, that it's a laudable aim in theory. They want to build a system that enables the creation of beautiful places that will stand the test of time. But I suppose really the question is how in practice is that done? It sounds great in theory, but how within planning do we do that? And indeed, I mean, I've only been in practice for I think just over 5 years, but even that language of beauty is unusual, and it's not something that we as professionals are used to dealing with. And if anything, I remember being positively discouraged from using that sort of language and approaching proposals in that sort of way when I was a pupil and doing my training. It's just not how as professionals we're taught to think about it. But it seems that that may be set to change. So in terms of the tools that are included in the white paper for achieving this aim, really there are two, and I'm going to talk about them briefly in turn. The first are design codes, and the second is the expansion of permitted development rights, and really to include what's called pattern book development. So if I start with design codes, there's already some national design guidance that the government has produced, but we're told that a national design code is on its way, and that will set out detailed parameters for development in different types of location. And I think a question that's often asked with these design codes is, well, how can you codify design? By definition, it's such a subjective area. What's beautiful for one person and well designed is not to another. But we do have some indication of the kind of things the government is looking for. Will provide. I've set out on the slide arrangement and proportions of streets and urban blocks, positioning and hierarchy of public spaces, successful parking arrangements, placement of street trees, high quality cycling and walking provision. Now I just pause there to say that at least I can easily imagine a development which ticks all of those items on the list, but is incredibly ugly, or at least the vast majority of people would consider it to be incredibly ugly and or poorly designed. But I suppose by definition, if you're going to codify design, you can't have a box that says pretty or attractive. You have to break it down into elements of design, and so perhaps it does become this rather banal tick box exercise, or maybe that's a bit unfair. It's more just basic minimum practical standards that developments need to have. And then the second element is this desire to have local design codes. So you've got as an umbrella design code that from central government, but then individual areas are supposed to produce their own design codes. And the white paper says that that will be done via local planning authorities or neighbourhood planning groups and site-specific design codes. And that really, I'm talking about growth sites, because the white paper says that a mandatory condition on this outline planning permission that results from the local plan for growth sites is a condition to have a site-specific design code and also a master plan. So the next question then, I suppose, is, well, what's the point of these design codes? How are they going to work in practice? And it seems that national policy will be amended so that compliance with these design codes becomes a weighty factor in favour of approval. So if you like, that's the carrot. You're more likely to get planning permission if you comply with the design codes. What's not at all clear, and something that I'm interested in, is the extent to which it's also a stick. So is it only the case that it's a positive factor that gives you brownie points if you comply, or if your development doesn't comply, is that a weighty factor against the grant of permission? We just don't know that at the moment. And then, of course, I suppose this links to what I said earlier about what the content of these design codes will be. But clearly, the specificity of a design code and the stringency of the requirements is key to giving the design code teeth. And as I said, there's a query about how specific codes can be in the subjective world of design. And then if you are really setting stringent, demanding standards requiring really high quality in terms of design and beauty, does that then have implications for viability? It seems to me that it inevitably does, if the government is genuinely being really, really ambitious about design for development. So that's part one. Quickly on the expansion of permitted development rights. And this is key to what the government refers to as the fast track for beauty. The idea is that in renewal areas, the government will extend permitted development rights for, and I quote, popular and replicable forms of development. And so, of course, that means that no planning permission is required. If your type of development benefits from these new permitted development rights, you don't need to make an application for planning permission at all. So that is really genuinely a fast track, if you like. There's still very little detail about this, but it seems that the government will develop, presumably following a consultation, a limited set of form-based development types to allow the redevelopment of existing residential buildings, and that's called pattern book development. So that would then establish the principle of the development, and then an application would have to be made to the local authority in the usual way for prior approval, so in respect of details like materials, access, flooding, and so on. And then it seems that local authorities will have the ability, just as they do with other types of permitted development rights, to modify how those standards apply in their particular area. And it seems the expectation is that local authorities would adapt these pattern book rights depending on what styles and forms of development are popular in their specific areas. I think it's definitely an interesting proposal. I suppose I have some concerns about how attractive it's going to be to developers in practice. And that's because actually, although it sounds very impressive to start with, I imagine that the scope for it to apply is actually quite limited. First of all, what are the conditions? When are these rights going to apply? And indeed, if local authorities then modify the right, or effectively withdraw it or modify it so that there are so many conditions it doesn't have any bite, then it's not going to be particularly helpful. It's also, bear in mind, going to apply in very limited, quite limited circumstances anyway. It's concerned with redeveloping existing residential buildings. So in other words, the aim is to increase density. Now, I'm not saying that that is not a laudable aim, and in some cases there'll be really interesting development opportunities that arrive in that context. But such is the housing crisis and shortage of homes that really it's going to be a lot more about change of use to residential, and indeed creating residential where there is none, rather than taking existing residential accommodation and remodelling it, redeveloping it so as to increase density. So I'd be interested to see what others think. I think it's an interesting idea, but I'm sceptical as to whether it's going to produce any sort of radical change in terms of increasing housing numbers.
Thank you, Kathleen. And you've just got up on the screen our contact details, our email addresses if you need to contact us. In terms of Kathleen's presentation, it strikes me on a number of these, and the expansion of PD rights is one of them, is how keen local politicians would actually be to giving up, if you like, an input and a control over, if you like, over design. So firstly, have we got any questions from the panel for Kathleen?
Yes, just a quick one, Roland. Catherine, it's very interesting. I think beauty, I think you're right to say, the use of the term beauty is sort of unprecedented almost in planning policy terms, and it strikes me that it's a highly subjective term. And I just wondered if you had any thoughts about, obviously, that the process of codifying beauty is an important one, and I just wondered if, to me, the process of drawing up design code is going to be therefore very important. And I think you set out in your presentation there's 2 or 3 different stages or processes at which design codes will be required, whether that be to support an outline planning application or whether it be developed by the local authority. Does the white paper say anything at all about the processes in developing a design code? Is there a consultation involved in that? Because from what I understand, it's separate to the plan making process, but it seems to me it'd be quite an important process to go through.
Yeah, good question, Andy. It does say a little bit, but as with much of the white paper, it just sort of dangles these interesting ideas but doesn't go into a lot of detail. What it says is that a rigorous, I'm paraphrasing by the way, but just in interest of time, a rigorous process needs to go through. Oh, actually, I found the exact bit. In all cases, it will be essential that they are prepared with effective input from the local community, considering empirical evidence of what is popular and characteristic in the local area. And then it says that basically the codes only get weight in the planning process if they've complied with that process. So I think it's quite ambitious. I mean, it's like a sort of little mini local plan process. The idea is that consultation goes on and there's a proper evidence base. But beyond that, we just don't know how these will be developed. And so I think it's watch this space really. And I think, well, it's also, we've got to see what the interest is from local people, because as with most of these things, there's a balance to be struck. If you make it so incredibly demanding and time consuming, then nobody will face doing it. But then equally, it has to be properly drawn up and sensible and robust so that it can then actually form a meaningful contribution to decision making later on. So we'll just have to see how that pans out.
Thank you, Catherine. Yes, I think your comment about there not being a lot of detail in the white paper, it does occasionally make me wonder whether they've actually come up, they're throwing out some general ideas and just asking the professions to come back with how they might possibly make it work. In other words, they're asking us to do their thinking for them. Whether that's a wise idea or not, asking a bunch of planners and lawyers for their ideas, I'm less certain. But I mean, certainly I know we'll be responding, and I assume your chamber and others should be responding to these changes in terms of how they might work. We've had some questions in from the people who are participating, and one of which, and I'll put this both to Victoria and Catherine, because it is kind of legal, I suppose, and it's about two things really. When you have recently adopted plans, if they were adopted by a local authority who then cease to exist because they've been incorporated into a larger authority, what is their status? And secondly, should plans be considered out of date on the date of publication if they no longer are in alignment with the most recent guidance?
Roland, I can have a stab at those. I mean, the second one, I think it's almost undoubtable there's going to have to be some transitional provisions, as for example there were when the MPPF changed, and we've still got plans going through under the 2012 system. So I think we will just have to see what any legislation and policy guidance says. And then in terms, again, the answer in relation to what happens to a plan if the local authority ceases to exist. Again, local authorities, when they cease to exist, that is dealt with by statutory provision. And again, there's no one size fits all rule, but generally provisions are in place for that plan to continue until a new one then comes into force. So at least that's been my experience. I don't know, Catherine, if you've had experience of that.
I mean, I have to be a little bit careful what I say about this, which is why I hesitated to answer, because I am advising an authority where things like that have happened. But as Victoria says, I mean, it depends on exactly what the statutory mechanism is underpinning the new authority. But at least the one that I've been looking at, there are detailed transitional arrangements, and so it's just a case of looking at those, and it's certainly not the case. I fear this might be bad news for the person who asked the question, I'm afraid, that the previous local plan just gets binned. It doesn't, it just continues to apply in its new context.
Thank you. Yes, I mean, transitional arrangements, I think, as Andy touched on, to some extent, the bane of our lives, because, I mean, they have been extended in terms of the 2018 changes, which effectively are going to leave us with potentially in theory, up-to-date local plans based on the 2012 guidance well into the mid-2020s, which surely can't be the way of carrying on planning. In other words, what one might see is we might actually see a plan or planning authorities leapfrogging several changes before they adopt the next plan. So you know, they just don't adopt a plan in the period where the policy environment is less favourable to them, and they just hold the old one. Another one, just another one coming through, which is about politics. I'll ask you, Andy, because you deal with central beds in Bedford, amongst other places. And I kind of know the answer to this, but it's a great question. So, do you think that local politicians should get together, or parties, and agree something, so that when the plan goes forward, there won't be political change, and therefore, you know, a change of party, if you like, will not impact upon the plan? I'm smiling a little bit because I know Victoria's also looked at Uttersford, which has had a similar position. But your idea?
Well, yes, I mean, in an ideal world, politics would be completely divorced from planning, but unfortunately that's not the world we live in. I think, yes, obviously there would be a lot of merit in cross-party consensus on these things. I think we as planners, we too often see local plans being used as a bit of a football, really, between political parties. I think Uttersford is an obvious example. North Herts I touched on. South Oxfordshire is another you could quote. And unfortunately, it is used. The local plan is quite divisive, and we've seen in Uttersford, you know, elections being won and lost on what people propose to do with a local plan. So, yeah, cross-party consensus would be highly beneficial to us as planners, I think.
And I suppose building on that idea of cross-party or consensus, at least, Victoria and Catherine, the new standard method that I described, step 3, if you like, where a figure that comes out of, if you like, the mechanics of the maths is then moderated by government and given to local authorities. I suppose the question there is could they do that without being subject to challenge? If it's a black box, effectively, is it all come under planning judgment, or how would that be looked at? And I suppose to put that in context, rather than, we know Central Bedfordshire have argued that the standard method under 2018 doesn't apply to them. They've got, if you like, a pass from just being an exemption from government policy on that. So how would that argument, if you like, play with the new one?
Well, shall I say a few words first, and then I'm sure Victoria will have things to add. I mean, my view is that there's going to be the mother of all judicial reviews when this new method gets announced. I mean, just so that we're all clear, there's obviously 2 issues here, and it's quite confusing that the government's decided to consult on both at the same time. There is the consultation on the standard method, which applies to the current planning system, but then there's also this entirely new method that none of us know how it's going to work, whereby the government nationally and centrally sets the housing figure for local authorities. And it's effectively the policy on figure that the government will be setting. So they'll look at the housing need using whatever method, maybe the existing one or whatever else, but then the government will look at constraints and then decide what local authorities need to actually plan for. There is zilch in terms of detail in the white paper as to how that is going to be done. And so we're all kind of scratching our heads and wondering, but it seems to me that this is going to be highly vulnerable to challenge, and the government will have to think really carefully. And as you say, Roland, I mean, it can't just go for a kind of black box approach. That's just not going to be lawful. It's going to have to, in broad terms at least, explain what the rationale is, give reasons for what it's done and the basis. And it's got to be rational decision making. It's got to, you know, be based on some sort of, you know, sensible policy decision and evidence. Quite how it does that, I mean, I genuinely do not know, and I think it's really, really difficult. How much detail is the government intending to get in? Is it going to look at local authorities individually and do a sort of mini local plan for each of them? Or is it really going to have some kind of crude algorithm, which I would have thought will make it very vulnerable to challenge? I mean, what about things like release of land from greenbelt? There's a very specific process, legal process, exceptional circumstances that local authorities have to look at. Will the government do that on their behalf, or is greenbelt just so off limits they won't even think about it? I think there are huge, huge questions to be asked, and I look forward probably to getting involved in the challenge, some one party or another. I wonder what Victoria thinks.
Thanks, Catherine. I mean, I agree, and I think I'm going to give a really boring lawyer's answer, which is it depends. And I think one of the big things that the potential for challenge will depend on is how much of this is in legislation and how much of it is in policy. Because if this is something set down in legislation passed by Parliament, then, you know, once the timeframe for JR has gone on that, then it's there, it's in our statute law, and the courts will apply it. If it's something that's simply left to policy, then it's a little bit more opaque, I think, because policy, the general rule is, and this is a point which would apply to the new standard method under the current MPPF and any new policy brought in. The rule is that you can have your policy set out in really strident terms and look pretty black and white, but actually when the decision maker comes to apply it, they can't fetter their discretion. So what they can't do is just rigidly apply the policy to every scenario. They have to exercise their discretion, which means that you can do something different to the policy. And I mean, it hit the headlines when the government brought out their written ministerial statement dealing with affordable housing on small sites, and there was a challenge to that, and everyone said, oh, that's contrary to section 38.6, or at least the claimants did. And actually the Court of Appeal eventually said no, because any policy, however it's framed, you can move away from it. So I think that is going to be a key issue for any challenge. And, you know, I think, as we've all emphasised here, is that the detail's just not there. But anyway, I don't envy the practical task that the Secretary of State's going to have with, so I don't know how many local authorities. It's not over 300, I think, well, trying to work out what their constraints are, and then set housing figures and the policy on figure accordingly. So, yeah, a lot that's up in the air.
Of course, one of the things that we learnt from regional spatial strategies, I suppose, is that what it did do is it gave local politicians someone else to blame when they got a number, and it was almost a case of, well, we have to plan for this because we've been told to. And it was quite a good get out for central government as well, because they would say, well, we haven't made the number up. So that seemed to be quite a good way of avoiding of getting numbers there that need to be planned for, but no one having to really take responsibility for them. I'm not saying that's what politicians are trying to do, but it's interesting they put themselves in the firing line for this, I think. Andy, to go from, if like, the strategic down to the specific, in terms of design codes, how detailed do you think they might start getting in terms of growth areas and renewal areas? And if they're getting really specific, what's that going to have? What effect is that going to have, do you think, on viability? I ask this because I know that you do quite a amount of development management work. So.
Thanks, Roland. Yeah, I mean, I think there's 2 points there, isn't there? There's a point about speed and the process, and also, as you mentioned, viability. And I think inevitably, I mean, we've done design codes for major sites, and inevitably they do add a layer of additional detail, at least additional work complexity that has to be agreed between parties, whether that be consulted on or discussed with the local authority. But I mean, I think if the government is serious about this ambition to build better quality, then maybe that's a price worth paying in terms of speed. If, you know, people will accept a slightly slower process if things are better. In terms of the viability side of things, I think what's important is that those design codes, and it links back to the question I sort of put to Catherine, really, was about how those design codes are drawn up and whether it's a transparent process, and also what stage in the process they're drawn up. Because I think, you know, from a developer's point of view, if you know about a design code at an early stage when you're acquiring a site, you can factor in the costs associated to a certain extent with that design code when buying a site or putting an offer in on the land. So I think it's important that those design codes are developed as early as possible. If it's alongside the local plan, then great, and then at least everyone knows where they stand. I think the difficulty is if they're done in a piecemeal fashion later in the process, mixed up with everything else that's going on. I think that's when, you know, development industry will start to question whether things are viable.
Thank you, Andy. And I realise we've overrun, but people are still staying with us. But just to before I sum up, 2 questions to all panel members, and this 2 simple ones, which is, firstly, just name one aspect of the white paper which you consider to be an improvement, and secondly, identify one opportunity you think has been missed. Now Andy's just been speaking, so I'm going to go to ladies first. I think I'll go to Victoria because she's top left on my screen.
Thanks, Roland. I think there are a few things. I like the emphasis on design, albeit the issues in implementing it. But I think my top choice would be doing away with SIL. I mean, no one likes it. There's got to be something better. Whether the infrastructure levy will do that, I don't know. But I'd love not to ever look at the SIL regulations again. One opportunity that's missed, and I think the general undertone is a failure actually to appreciate planners and planning and how nuanced and complicated and site-specific it is. And, you know, it's true that when things go right and a place is properly planned, then you almost shouldn't notice it. And it's only when things go wrong that people notice it. And I think the failure to recognise the complexity of that process and the skill involved, there's a slight undercurrent there with this sort of sweeping everything away and sound bites and, you know, let's all make it simple. So that's just a sort of sense I have. More love for the planners, I think.
Well, we're not going to say no to that, are we, Andy? Catherine?
I really admire the ambition of it, even though I know I've been quibbling about the lack of detail. But one more specific thing that I really like is the drive for concision and brevity. Because I think it's something that as an industry, and by the way, I include lawyers in this, absolutely, has kind of fallen by the wayside, and it's one of the reasons that members of the public find it so difficult to engage with as a system. And actually, as we all know as professionals, to get all of your points covered concisely is really, really difficult and takes real skill. And so I really welcome that. And I mean, particularly things like development management policies in every individual local plan. And, you know, so much of it just seems to be duplication. And, you know, I really do welcome the drive to do that more clearly and efficiently. In terms of opportunities missed, I suppose linked to what Victoria said, I think the resourcing of local authorities in terms of training and also just hard funding is absolutely key to making the planning system function properly. And there's all this sort of vague waffle about, you know, supporting them and training and lots of stuff about digital. But I'm afraid unless the government is prepared to pump some serious money into the system, particularly to support the bedding down of a new framework, I think it's doomed to failure, and they just need to be honest and upfront about that.
Thank you very much. And Andy?
Thanks, Roland. Yeah, I mean, the one thing that I'm particularly welcoming of, I think, is this idea to digitise the system. I think in many respects, I think with planning systems been left behind. I think, you know, putting up hard copy site notices out on telegraph poles hopefully are now a thing of the past, and sending out hard copy letters to all neighbours just seems a bit archaic to me. So I think that's something that definitely does need to be implemented quickly. Although I would echo the point that Catherine's made about resourcing and enabling local authorities to do that properly. The other opportunity missed, I think, probably the elephant in the room in some ways is the green belt, and I think a lot of people have commented on this, that it really doesn't sort of address the green belt. It's sort of as you were almost approach, and I think, you know, that, as I say, is the elephant in the room in terms of housing delivery that seems to me it needs to be looked at.
Thank you. And my two, I'll just chuck them in there before summing up. Firstly, speeding up of the local plan process with the one consultation is something we recommended in one of the consultations, I think a number of years back actually, to government, which reminds me for people to get out there and make sure their views are known to government by the end of the month, by the 29th. But our idea was not only do you only have one consultation, but you treat it like, if with allocations at least, you treat them like outline consent. So you notify everyone surrounding that allocation, so it doesn't come as a surprise when the actual planning application comes in, and then they're notified, and people turn up and say, well, I don't know about this, which we've all had, you know, for when we've gone in and promoted allocation. So I think I would support that. In terms of what I think is the opportunity missed, it's kind of linked around, I don't want to say the word strategic planning because I know they're not popular, but in setting a housing requirement, or calculating a housing requirement, if you like, doing away with the duty to cooperate, which hasn't worked particularly well, but there's nothing to replace that. And when you have London, for example, and the impact on London on the housing market of the country as a whole, failing to address undersupply in London in any convincing way, I think is something that's really an opportunity that's been missed. Now, you can do it in a number of ways. You don't have to call it the S word. There's other ways of coming up with housing numbers to try and deal with that. But I think that would be my opportunity missed. So, as I say, we've overrun, but most people have kept with us. So those of you who've kept with us, thank you very much indeed. Thank you to our presenters. This time that's Victoria Hutton, 39 Essex, Catherine Barnes, 39 Essex, Andy Parry, DLP from the Bedford office, and myself, DLP stroke Sprue. And also can I thank Kirsten, who is behind the DLP logo, who's actually managed to make this all run very smoothly, despite having a slight hiccup with the with her internet earlier this morning. So well done, Kirsten. Just to recap, we will be sending around a copy of the presentation, and we'll also send around, if you like, a list of key takeaway points for those who've participated. And I think this is one of the number of presentations we're doing online now. And just as a comment, there's some small changes going on in terms of how we're operating, both online and indeed things like local plan examinations, where we've all started doing those online. We attended the first one in South Oxfordshire that seems to work quite well. We've just been at one in Doncaster, which is a blended event where we've had both people in the room and then people in the council chamber, and then people, if like, coming into that, and that's worked really well. So well done for Doncaster, and well done for their very new offices up there. But I think these small changes actually might have almost a bigger impact in terms of how planning is delivered in the future, as if you like things like the white paper. And it's good to see that that most people are actually encompassing that. So thank you all, and we will notify you obviously of the next DLP webinar. And thank you again to our fellow panelists. And that's it for me. Good afternoon. Bye now.